name's Jay McDaniel. I'm a principal with the McDaniel Law Firm with offices in Hackensack, New Jersey and New York City. Today we are going to talk about American Chopper. Who doesn't love American Chopper? I love to watch Paul and Junior fight. And all of the fans of American Chopper are pretty much aware that Paul fired Junior about a year ago and that litigation started. Well, that case has been winding its way in the State Supreme Court of New York. Essentially, the lawsuit involves a letter agreement that Paul and Junior signed in order to keep the show on the air. That agreement said that Paul was going to buy Junior's shares in Ocean County Chopper at a price that they would agree upon later. And we're going to talk about what that means and why sloppy drafting really didn't help them very much in this case. But the long and the short of it is that the show got canceled anyway. They went to court, and at the trial level, the judge held that the agreement at a value to be agreed upon by the parties was sufficiently definite to be enforceable. It was appealed, and the appellate court reversed, and here's why. An agreement to agree is not enforceable. An action between the owners of a business in which one of the owners is trying to force the other owner out, or there's some other dispute between them that requires the business to be valued. There's a specific standard in New York and in most states as well, and that's fair market value. Fair market value, although anyone who's ever litigated the issue of fair market value would know that it's a difficult term that can mean a lot of different things. It still has an accepted meaning. That's a big difference from agreeing that there'll be a value that we'll decide upon later. And in this case, the failure to include something that could be objectively judged, such as fair market value, was fatal to that letter agreement.